And this, I think, is so important for our COVID era, because this, I believe, is the thing that went wrong in COVID. To use the court analogy, it would be a little bit like having a trial where only one side is allowed to call evidence, where only one side is allowed to bring witnesses, where only one side is allowed to make their case, and the other side just has to keep silent. They can't bring their own witnesses. They can't object to anything that's being said. They can't cross-examine the other side's witnesses, that they're basically just, bound and gagged effectively. When justice is done, it's a joy to the righteous, but dismay to the evildoers. I, for one, am joyful given the recent federal court ruling about the invocation of the Emergencies Act. Specifically, what the court found was that the Trudeau government didn't meet the high threshold in the act to declare an emergency, and also that the regulations that came as part of that invocation, such as the freezing of bank accounts, that those and some other things were against people's charter rights. I think this is an important victory for people who, like me, and perhaps you, who feel that the government has been very heavy-handed throughout COVID, and especially when it came to the invocation of the Emergencies Act. This decision, I've had a chance to read through quite a bit of it, not cover to cover, it's 190 pages some odd, but I've read the decision fairly carefully, and there's a few things in it that I want to discuss. Actually, there's some things in there that I find actually quite refreshing, and I couldn't quite put my finger on why I found it refreshing at first. And aside from finding it refreshing, I also found it rather boring. Now, I know that doesn't sound like much of an endorsement for reading it, but if you haven't done so already, I would encourage you to take a few minutes. I'll put a link in the description. Have a look at this decision, read a few paragraphs, read the conclusion if you'd like, because I think it is sort of an important piece of our history, and it gives a glimpse into how our judiciary works. Now, I found it boring, and I think that's actually a good thing when it comes to a court decision. It's kind of the opposite of what you see on social media and even on the mainstream media and in our political discourse. What I found Justice Mosley doing was basically being very careful and deliberative, kind of working through the logic of the law and kind of going step by step by step, making these sort of little micro decisions or micro judgments along the way to finally arrive at this larger decision. I know I'm not selling it very well, but it's a little bit like watching someone doing a complex math problem on a chalkboard. Maybe that's a bad example, but something where it's basically just arithmetic, basic math, but it's just a matter of crunching through, solving your different variables and plugging them back in. As you read this decision, you realize that he's careful, he's plotting, he goes from A to B to C. He's talking about even how he's approaching things. He's citing different laws and other cases on how he interprets different bits. It's refreshing because it's sort of the opposite of what we're doing in our society, I believe. The other thing that stood out to me is that Justice Mosley seems to assume that there is some objective truth out there, that the law can be applied objectively. And I'll get more to that in a few minutes, but this is something that we seem to be lacking in our society, that there seems to be more about what we feel as opposed to there being an objective truth out there. Now, on the sort of logic side, that careful deliberation or following logic, in looking at some of the reactions to this decision, I've seen things on both sides, and there's a couple of examples. These aren't necessarily verbatim what I saw on Twitter, but they catch the gist of it. There are some people who were against the invocation of the Emergencies Act, as I was, who were saying things like, well, Trudeau's acted illegally, he should be thrown in jail. And then there's people on the other side saying things like, well, the convoy was loud and disruptive to the city of Ottawa, therefore it was justified to invoke it. Now, both of those are faulty logic, or at least incomplete logic, and I won't get into the whole thing, but clearly not everything that's illegal means someone has to go to jail, and just because something was disruptive does not mean an Emergencies Act, or the invocation of that act, is justified. And Justice Mosley breaks these things down and kind of go step by step, avoiding that sort of emotional, like, I don't like this thing, therefore do whatever you need to do, or I like this thing, therefore we must always do it. This sort of emotional response that we have. In terms of this objective threshold, this really stood out to me, and I'll get to how it's different than the Rulo Commission report in a few minutes. But it seemed clear to me that he is attempting as best he can to apply an objective view of the law. And for example, in paragraph 210, he writes, "The Emergencies Act contains objective legal thresholds that must be satisfied before a proclamation may issue. And these thresholds are more akin to legal determinations courts make governed by legal authorities, not policy." So what he's saying is there's an actual test out there, and I won't go through the whole details, of whether or not a threshold of an emergency is met, and that these are objective, and it's not just the government saying it feels that way. Whereas Justice Rulo's decision, so this is the Public Order Emergency Commission that found that Trudeau was justified, he takes a different approach. And as I read Rulo, what he seems to be saying is that Rulo believes that the Prime Minister and the government earnestly believed that they had met the threshold. So it seems like Rulo is asking whether or not they truly believe this thing versus whether or not a threshold was actually met. They sound similar, but the distinction is very important. So here's what Rulo, so not Justice Mosley, part of his summary is as follows. Rulo writes, "There was little suggestion by the parties that the subjective requirement had not been met. That is, that Cabinet did not genuinely believe that the statutory requirements for a declaration of a public order emergency had been satisfied." Then he goes on, "The federal government undertook a thorough and structured analysis and, applying the law as it understood it to be, Cabinet and the Prime Minister believed that the threshold for declaring a public order emergency had been met." So Rulo's talking about whether or not they believe that they met it versus it actually being met. This is an important distinction. Now, some of this was in the Public Order Emergency Commission, the Rulo Commission. This got kind of muddled up, if you recall, with this whole business of David Lametti, the then Attorney General for the government, basically using solicitor-client privilege to not answer certain questions. So it's kind of circular where, and I have this at a high level, but as I understood it, it was like the Prime Minister and Cabinet in general saying, well, we felt that the legal threshold was met because that's what our legal counsel told us. And then you ask their legal counsel, David Lametti, and he says, I can't share what I told them because of solicitor-client privilege. And then he's asked, would you, or the government, or I think Trudeau is asked, will you waive that? And then the government lawyers object to that. So they kind of seem to hide behind this privilege. And anyway, Mosley sort of doesn't care about that, it seems. He's more interested in whether the objective threshold of the act was met. One thing that I've noticed on Twitter and in some of the discourse here is there's a lot of people who were in favor of the Emergencies Act who are pointing to one specific passage in Mosley's decision as though it helps their point in saying that the Emergencies Act was justified. And to paraphrase The Princess Bride, I don't think that paragraph proves what they think it proves. So I'm looking at paragraph 370. I'll read it here. And this is important. I think anyway, we'll get into it. So this is Justice Mosley, paragraph 370. At the outset of these proceedings, while I had not reached a decision on any of the four applicants, I was leaning to the view that the decision to invoke the Emergencies Act was reasonable. I considered the events that occurred in Ottawa and other locations in January and February of 2022 to be beyond legitimate protest and reflected an unacceptable breakdown of public order. Now, I happen to disagree with his characterization of the protest, but that's kind of beside the point. And to Justice Mosley's credit, he doesn't let this bias going in affect his ultimate decision. And that's what I want to talk about. And I won't read it here, but in paragraph 35, he has some other sort of scathing things. Well, maybe not scathing, but sort of unkind things to say about the convoy and diesel fumes and incessant horn honking, etc. My point is that Justice Mosley, was in no way a fan of the Freedom Convoy. So he admits that he was biased, that he was leaning toward the government position. He admits that he didn't like the convoy personally. That's what I take from that. Yet he comes to a decision that finds that Trudeau did not meet the threshold. And this is really important. And I want to kind of unpack. I mean, the question is, if he has that bias, how does he come to a different decision? Because it seems like in our political discourse, if I don't like Trudeau, then I'm going to find anything Trudeau does to be wrong. If I don't like Poilievre, I'm going to find that anything he says or does must be wrong. And we sort of start with our position and then reason from there. To his credit, Justice Mosley is not doing that. He acknowledges that he has biases, but he comes to a conclusion that is actually against his bias. And he gives a clue here. This is paragraph 371. My preliminary view of the reasonableness of the decision may have prevailed following the hearing due to the excellent advocacy on the part of the Counsel of the Attorney General of Canada, had I not taken the time to carefully deliberate about the evidence and submissions, particularly those of the CCLA, that's the Canadian Civil Liberties Association, and the CCF, that's the Canadian Constitutional Foundation. So this is interesting. He's basically saying, as I understand it, that the government lawyers in his hearing, I guess, in his judicial review, he thought the government actually did a good job, but he's saying that the CCF and the CCLA brought really good argumentation as well. He has some less nice things to say about some of the private applicants, but I'll put that aside for the time being. You can look at the decision if you'd like. He goes on to say their participation, referring to CCLA and CCF, their participation in these proceedings has demonstrated again the value of public interest litigants, especially in presenting informed legal argument. This case may not have turned out the way it has without their involvement, as the private interest litigants were not capable of marshalling the evidence and argument in support of their application. So again, those are those private interest, those are people who had their bank accounts frozen, and he doesn't look as favorably upon them. As I understand it, not so much for their case, but maybe their legal arguments, maybe their counsel wasn't as sophisticated or as well-resourced, that is more of a procedural thing. That's what I gleaned from it. Anyway, we'll leave the private applicants aside here. So he's basically saying that both sides did a really good job. And that's interesting because we could have, and again, in a slightly different world, and there are some judicial traditions, as I understand it, that would take the approach I'm about to talk about. We could imagine a world where we take someone as learned as Justice Mosley. He's not a stupid man. He's spent a lot of time in law. He's well educated, I'm sure. He's careful. We could have said, Justice Mosley, just on your own, investigate this and find out if you think it's justified. But that's not what our court systems actually do, which is an interesting and important point. We have what's called an adversarial system, and that is where you take the good arguments from the government, as Justice Mosley points out. They had good arguments, and the CCLA and the CCF had really good arguments, and Mosley was already leaning toward one, but our system puts those things in conflict with one another, puts them in an adversarial position where they basically attack one another's arguments. If you think of it this way, there's very few people, well, there's really no people that I know of that are like purely good or purely bad, or that have purely good ideas or purely bad ideas. That most of us have some good ideas and some terrible ideas. So the idea is you put them in this adversarial context that is well orchestrated, and there's procedure and all kinds of things. And what you get left with is sort of the bad ideas, or the things that are unfounded, things that are poorly thought out. Those get kind of, burnt off, if you will, or skimmed off, and you're left with the essence of the argument. It reminds me of this idea in the Bible. There's actually several places here, but there's a passage in the book of Malachi where he talks about a refiner's fire. The quote is like this. This is from Malachi chapter 3. For he, God, is like a refiner's fire and a fuller's soap. He will sit as a refiner and purifier of silver, and he will purify the descendants of Levi and refine them like gold and silver. I think the analogy here, and there's other allusions in the Bible that talk about fire sort of purifying, the idea that what's not sound, what is dross, what is weak, that those get skimmed off or burnt off, and what you're left is what is the essence, what is pure, what is good, what is truth, perhaps, in the context of a judicial review. Similarly, in the John the Baptist talks about, I think certainly in Matthew's account, and I think Luke's account as well, and I'm paraphrasing here, but John the Baptist says that there's one, meaning Jesus, that's going to come after me, and he's not just going to baptize with water, he's going to baptize with the Holy Spirit and with fire. And it's that fire sort of an odd thing. But I think it has something to do with this refining, the getting rid of what's not pure or what's not true and leaving a true essence. So our justice system is an adversarial system. And I think that's ultimately good. And I think we're losing this in our culture. This isn't something that we have just in our judiciary. And it's worth noting that I did a little bit of research here. Justice Mosley, he cites all kinds of case law. And so the whole idea of English common law is we kind of build this edifice over, literally centuries. I mean, apparently it started in the Norman conquest of 1066. And frankly, probably has antecedents that go back even further than that, probably to biblical times and classical Greek period, I'm guessing. But that's sort of beside the point, that we have this system that's built up where we find out what is true by putting two opposing sides together and seeing what is left. And this, I think, is so important for our COVID era, because this, I believe, is the thing that went wrong in COVID. We said we would not tolerate debate, dissent, or discourse. We basically said that this is so important, this emergency is so severe that we can't speak against it. We can't ask any questions. We can't oppose the narrative. To use the court analogy, it would be a little bit like having a trial where only one side is allowed to call evidence, where only one side is allowed to bring witnesses, where only one side is allowed to make their case, and the other side just has to keep silent. They can't bring their own witnesses. They can't object to anything that's being said. They can't cross-examine the other side's witnesses, that they're basically just, bound and gagged effectively. So again, getting back to Justice Mosley, he's a learned man, and by his own admission, I think what he's saying is if it was just up to him, this learned man, he would probably side with the government. But that's not what he did. He's pointing to the system. This system is greater than him. It's greater than any litigant. It's greater than the government. It's greater than the CCLA or the CCF. That this process of getting at truth or navigating our way through a complex situation is really valuable. It's more valuable than any one person's opinion. I think the CCL did a great job here. Should we put them in charge of all of Canada? I don't think so. I think they're probably incompetent in many other areas. But we should take their ideas and put it in an adversarial position against other ones and see what comes out. This has been, like I said, the ultimate failure of our COVID era, that we would not allow debate, dissent, discourse among people. And instead what we got is basically collusion, with dissent being silenced. We've got big government and big media and big pharma pushing what essentially turned out to be snake oil on the populace. And I think that could have been avoided had we allowed and encouraged vigorous debate. But it's interesting that was the first thing that got shut down. There seems to be this idea where truth hurts. We're concerned about people's feelings being hurt. We are concerned about, so like I said, true things hurting our feelings. We see this recently with Tucker Carlson coming and seeing some of these liberal ministers and Rachel Notley, and they're kind of wringing their hands and they're worried about what Tucker Carlson's doing. They don't attack his ideas. They don't go like Justice Mosley did, point by point, and refute his ideas and sharpen his ideas perhaps, or say, I agree with him on this, but not on that. They don't do that. They basically say his ideas are dangerous. Even questioning the narrative is dangerous. We can't have dissent because there would be hurt feelings. Some people might be put off with who he is. That our feelings are more important, according to these people, than getting at the truth. We see this with the whole transgender question where, is there objective truth? Is my sex determined by my own feelings about my sex, or are there things that exist about my body, about my chromosomes, that are true irrespective of what I feel about them? It seems that our society is getting away from truth. Even this whole, like reading Justice Mosley, this idea of a careful, deliberative approach, we're told that that's white supremacy, or that's colonization, or that's just European thing. That's nonsense. This is something that we've built up. Europeans and others have come together to get to where we are. We've built this society based on believing that there's an objective truth and taking steps to find it, or at least move closer to it. Maybe you never quite arrive, but you can move closer and closer to it. And it seems that there's a lot of people out there that want to disconnect us from truth, that want to have us decoupled. I think that's dangerous for so many reasons. We're seeing it in universities. We're seeing it in media. We're seeing it in our judiciary. Thankfully, Justice Mosley hasn't seemed to fall into that. But I think we see it with our professional associations, like the Ontario Colleges of Psychologists with Dr. Jordan Peterson. Basically, his views are dangerous, that we cannot abide even thinking about these views. We need to shut him down. We need to shut down debate. We need to shut down dissent. We need to shut down discourse so that we can have this narrative. I think maybe these people know intuitively that if they allow their ideas to bump up against other ideas, that the weaknesses of their own ideas would be laid bare. But disconnecting from the truth, that's dangerous. We could think of the truth as being like a vine, and that we are the branches. And as long as we stay connected to that vine of truth, we can bear good fruit. But as soon as we become decoupled, as soon as we decide that we're not going to seek truth, that we just want to do things our own way based on how we feel, we become detached from that vine of truth. And if a branch is detached from a vine, which is tied into the root system, it can't bear good fruit. This is important. Justice Mosley's decision is important. It's boring, it's refreshing, but it's important that it points us back to this deliberative truth-seeking and this idea that there is something beyond ourselves, beyond our political affiliations, that is ultimately true. And we can argue about whether we've ultimately found it or not, but we can move ourselves closer. Decoupling from truth, that's going to be a disaster for everyone involved. Tell me what you think. Leave your comments below. Thanks for watching.